This one is under the category of mastering issue spotting. The tip is basically this. When you approach an exam, think colorable, not right. What exactly do I mean by that? Let's back up a second. One of the huge shifts that marks the transition from non-lawyer to lawyer is learning that law is a probabilistic endeavor. The whole discipline of law aspires to be something scientific. Juris Doctors are given out. JSD, which is the sort of advanced degree after a JD, which mainly foreigners take, is a Doctor of Juridical Science. Ha! Law is more of an art form. There's right and wrong, but it's a little bit difficult to explain to someone who's not in the law why something is right or wrong. The way in art there can be general consensuses as to whether or not some art is good or bad, but it's not so easy for the outsider to understand that. So before law school and with a lot of non-lawyer clients, people expect certainty. People think that with all the laws that are on the books, that it's very clear if something is legal or not legal. And suddenly, after you've left law school, you become hugely Bill Clintonian. And suddenly, you can boil any legal analysis down to this. It depends. And suddenly, you've gone to the dark side, and you're that hedging lawyer that everybody hates. So it's important to make this shift sooner before you start taking exams, because it's on exams that the shift from law as definite and science to law as something a little bit more probabilistic and artistic becomes clear. Don't think to yourself as you look at a fact pattern, does a law apply or not? That's way too binary. The way you really should think about something is, can I make a colorable argument that the law applies? What do I mean by that? Well, let's go back a second. The law is probabilistic. Why? Well, the law is written in things that look like this. There are actual books of law, but they're interpreted by people like this. Just to be clear, this is a judge holding a gavel and not a homeless dude holding a shovel and wearing a garbage bag. And even if it is a dude in a garbage bag, the key thing about this is this dude or dudette is human. And he's subject, even though I believe that most judges aspire to objectivity, they're swayed by things. Any of the errors of the mind that Malcolm Gladwell has written about incorrectly, this person is subject to. The other thing is that if the law were so easy to apply, we would just have robo-judge, and you could just apply the law. But the law is language, and language is elastic, and there is ambiguity, even unintentional ambiguity, that rests right over here. So, as a result, you can't think to yourself, does this law apply or not? Are you a robot that thinks just in ones and zeros? There is a spectrum, more probable and less probable. And colorable is right here. We've kind of talked about this before, but it may be on the lower end of probability, but it's something that still passes the laugh test. An argument that at least some judge out there might accept under some circumstances. So, drilling a bit deeper on this, in real life, and this gets back to exams, because exams are to this extent influenced by real-world lawyering. In the real world, lawyers have an ethical obligation as attorneys to engage in zealous advocacy. You can't just do what you want to do. You have to do everything that's reasonably possible to advance a client's interests. Now, as a lawyer, strategy is within your discretion. But if the choice is just between making an argument that sounds stupid but might fly in some judge's world and just going home and saying, I don't care, you have an obligation to try and make an argument, something to help your client. And I think this is what it means to be colorable. Your client's in a bind, things don't look good, and you make the best arguments that you can reasonably and honestly make, and still passes the laugh test. Because if you can't pass the laugh test, then you really do have to call it a day. So for you, what you're on the hunt for are colorable arguments, not just, yes, that fact was a claim, no, that fact was not a claim. So this is why at least in the system I like to use, when we come to conclusions on IRAC, tend to say in the conclusion, the better view is dot 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 or not, or the likely result is dot dot dot. But that's all you can actually in truth tell your client. Judges are crazy, juries are crazy. You don't know what might happen. So how does this get back to you on an exam again? If you can make an argument with a straight face, even if it's iffy, even if you don't think it'll win, even if in IRAC you won't conclude that that argument wins, in this phase, you have to try to come up with something. If the facts are even somewhat ambiguous, you have an obligation to come up with something. And this is not terrible real world training. You have real clients who walk in through the door in tough situations, and you've got to sit around and think, is there an argument I can make to save this client? That's the kind of energy you should put in doing an IRAC analysis, especially a closer question when you're going to do a he said, she said analysis, that the argument is rich enough that there are actually potentially two sides to it.